This case is only focused on a modification of child support based on a workplace injury and a subsequent some head trauma that I guess uh, reduced Mr. Lewis's earning capacity. There was a downward modification of his child support of approximately $100. He was paying approximately $304, and then based on this mod, he would be paying on the order proposed $206, and then he's still paying $72 in cash medical support. I believe the issue is most likely just simply the fact that of the reduction in the child support obligation. I'm not aware of any technical or material problems or concerns with the order itself. I'll let the party explain herself, but based on our review of the records and review of the court's ruling, this order has been prepared in compliance and in conformity with the court's rule. So we'd ask that it be granted as is, and that's all we've got.
All right, Ms. Hogue, the state's asking me to go ahead and enter this order that modifies the child support. The enforcement stuff has already been taken care of, and already all final. Is the state's understanding that you have some objections or some reservations of the court order as far as the lowering of the modifying the child support downward by approximately $100. So at this time, ma'am, on the record.
This hearing starts with a simple request to reduce child support after the father claimed a workplace injury lowered his income. But the mother isn't convinced. She argues he's still earning more than he's reporting and points to his social media posts as proof. The question now is whether those online posts are enough to convince the court.
The state's asking me to go ahead and sign off on that order, doing that, lowering that modification. Is there a legal reason, ma'am, why I should not? And if there's any reason why I should not, I need for you to tell the court at this point. Thank you, ma'am.
Yes, so I have evidence of Eric making way more than what he's reporting. And I don't know what injury he's talking of, but I do have evidence of him doing work.
All right, here's the deal, ma'am. What you may consider evidence and what I can may consider evidence may be a little different. So at this time, let me go ahead and ask you to raise your right hand and unmute yourself and turn on the video and raise your right hand. And let me get you under oath and you can tell the court what you understand that information is. All right, ma'am, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give here today is the truth, the whole truth, and nothing but the truth so help you?
Yes.
All right, ma'am, you can put your hand down and tell the court what you understand. What I know you're not a lawyer, so what proof do you have or what do you understand the proof is that the father is intentionally underreporting his income information?
Yeah, so I have pictures of him doing work from his social media and reporting those pictures and things like that of prices and everything.
Okay. And ma'am, what's your understanding of what is he doing for the earned funds?
So he is building things out of wood, whether anything that you want, a patio out of wood, he's building furniture out of wood. What is it? Carpentry, I think that's what it's called. Anything out of wood he can make. Shoe boxes, furniture, patios, and I have evidence. I have pictures.
All right. All right, then, ma'am. Again, I know you think that's evidence, but it can be, it may not be. But I got a quick question to the state. As far as current child, are we under the temporary order? Oh, I'm sorry. Are we under a temporary order that has reduced the child support to down to 204, Mr. Coates? Or are we still at the prior order 304 on the child support?
This would be a final, and just given a little bit based on the testimony that was presented at the last hearing, there was at least an argument that his condition would at least exist for the foreseeable future. So the state's position is just that it would make more sense to do it as a final. There was no pending indications that there would be an upgrade in his condition in the next, near future. That was his testimony.
All right, ma'am. Now, ma'am, do you have any eyewitness knowledge or eyewitness information showing that you've seen the father out working or earning funds? Again, stuff on the internet can be fake. It doesn't mean it's true and correct, but it doesn't show what his actual earnings are. So do you have any eyewitness information or anything he's told you that shows that the court should just go ahead and at the minimum keep the child support currently where it is, or reduce it down by 1/3?
Any eyewitnesses? No, I do not.
All right. And okay. Where does he live, ma'am? You know? What city?
Um, somewhere up there by Houston. I don't know the name of it.
All right. Does he have any specialty license? Is there anything that you know that he's done as far as being able to earn funds that he's done for more than a 2-year period? Like, was he a carpenter for 2 years? Was he a bricklayer for 2 years? Anything like that?
As far as certifications, no, I do not.
Just for the court's knowledge, Judge, he did report a $1,600 monthly gross wage.
Of course he did.
I just,
Ma'am,
yeah.
don't make comments behind it. All right, that's not appropriate. Thank you. All right. And how many other are we looking at? One child in? How many out?
I think there are a total of 3 kids. I think this is the only child that would be under a support obligation. I believe there are 2 other children in NCP's household, Judge.
All right, so the 1,600 is just about right around or just above minimum wage. So at 20%, instead of 204, you'd be closer to 240, correct?
Yes, Your Honor. The percentage, just so you know, that was in the order was 16%.
Okay, so there are 2 other children under the age of 18?
That's a good.
Your Honor, I'm not certain about the
Yes,
age.
they are.
Okay.
Okay. All right then. All right, ma'am. Again, if they were over the age of 18, I could do something about it. I was going to go ahead and change things around, but right now I don't see anything that I can do differently other than the fact, again, because there's no conclusive evidence. Evidence that is at least preponderance of the evidence of clear convincing that the gentleman is doing more than he alleges he's doing, as far as being able to earn funds. So I'm looking to go ahead and order current child support at 204. I'm not going to start that amount. I'm not going to go back to the date of service, Mr. Coach. I'm going to go ahead and order that to start the first day of April, since the first day of March is almost here. So I'll modify the child support to start the first day of April. Otherwise, it remains as is until then.
Is it 204 or 206?
206.
206. All right, 206, ma'am. Sorry.
Your Honor, I'm sorry. Can you check your docket sheet from 10-8?
All right. Okay. I'm sorry. I was looking at the last one back in April, and I'm sorry, in November. So we did something on 10-8.
Judge, yeah, we started in this order, the new support obligations, at least in the order that's been drafted at November 1 of 25.
All right, so I see. Okay, sorry. Okay, I see 1,600. Was it what he testified to? We said cash medical was 72 back then.
That's what's in the order.
And the child support was set at.
It was at 304 and then was reduced to 206 on this new calculation.
Okay. Man, what kind of health insurance do children have?
Medicaid.
Okay. All right, that. And those other 2 children, are they in the same household or are they 2 separate children?
I know one lives with his mom, and then the youngest one lives with him.
Okay. All right, so what I'm going to go ahead and do, Mr. Coates, I'm going to go ahead and reduce the cash medical to $36 in this case, and I'm going to go ahead and transfer that extra 36 over to mom, so I'm going to raise him back up to 240, okay?
Okay.
All right, ma'am. I'm going to move some money around, man, because the health insurance amount's a little high for three separate households, so I'm going to adjust that downward, and I'm going to give you the difference and start that the first day of March and I'll go ahead and start that the first day of March going forward.
So Judge, just so I'm clear, March 1, he will be paying 36 in cash medical, and then he will pay, what's the amount in child support?
240.
240. Okay.
Oh, I'm sorry, 242, 36 plus 30. I'm sorry, the judge is losing it. So yeah, it's 242. Sorry about that.
242. Okay. I'll redraft the order and then get it submitted to you.
All right,
probably
thank you.
tomorrow.
All right, ma'am, is there anything else?
I guess not pertaining to the order, no.
All right. Thank you very much, ma'am, and we're off the record. You're free.
Thank you for your time, ma'am. Thank you, Judge.
All right, does this hold be excused or you want to back and break out?
No, we're not waiting on signatures or anything because I don't have the order finished, so
All right,
we
ma'am,
can
you're
go.
free to go then. Thank you.
Judge, I think that takes care of me for the day, so I'll get out of your way.
All right, then let me finish writing this one up because I got to change what I wrote down. So yeah.
I get you.
All right, then. Just thank you very much, Mr. Coates.
Thank you, sir.
So my understanding is that the following, this is going to be a temporary order. We are requesting a final special setting for sometime in May on either a Friday or a Monday, preferably in the latter half of May. The parties will be named joint managing conservators, with the mother deciding the residence in either Bell or Coryell counties. The child support will be $431 a month, payable by Mr. Carter Maddox to Miss Johnson. Mr. Carter Maddox will also be ordered to carry the health insurance and dental insurance for the child, preferably through TRICARE as soon as possible. There's going to be an exchange of the child's copies of the vital records of the child so that he can add the child to TRICARE. And then there is going to be drug testing for both parties within 10 days of the court signing the temporary order. And that's going to be both a 10-panel hair follicle test and a UA. And both parties are going to be responsible for paying for that. I believe Miss Johnson is going to be using the any lab test in Harker Heights or Killeen or whichever one is there.
It's only Killeen now, sir. Yeah, Hawkeye's taking the shit down.
Okay, in Killeen. Mr. Maddox is going to have to find something close to Fort Polk, Louisiana, which is where he's at right now. And that, again, that's going to be within 10 days. The periods of possession are going to be as follows. It's going to be a two-step thing, and then for step one is going to be 4 days in a row, actually starting tomorrow. On specific times. I believe it's, let me see, I have it written down here. It's 4 to 7 tomorrow, noon to 6 on Saturday, 4 to 6:30 on Sunday, and 3 to 7 on Monday. Again, it's the next 4 days after today, actually. The Friday, Saturday, and Sunday are going to be supervised. There's 4 different individuals that the parties have agreed on that will do some or all of the supervising. And then the visit on Monday will be unsupervised. And the exchanges will occur at either the child's school in Gatesville or the police department in Gatesville or the police department in Temple, based on who's picking up and where they're picking up from. Neither parent's going to remove the child from the current school, which is in Gatesville. And that's step one. Step two is going to be from March 26th to the 29th. Or sorry, I guess it's the 28th. Yeah, it'll be the 29th. Yeah. So 6 p.m. on the 26th to 2 p.m. on the 29th. Mr. Maddox is going to take the child to and from school on the 27th, which is a Friday. And none of these overnights, none of the periods are going to be supervised in the second step at all. The exchange provisions from the first step are going to continue. And then once we get through those first 2 steps, we have, I guess, a third step that will be the reoccurring ongoing step until a final order. And this step requires Mr. Maddox to designate 4 days within each month that he will have possession and access of the child. And he will communicate both the start and end days and times to Ms. Johnson at least 14 days prior to the beginning of that period. And to the extent possible, we'll try to designate days that don't interfere with school. And of course, this step will not be supervised either. And then, and so it'll just be 4 days a month, designated by him 2 weeks in advance every month going forward until a final order. And I think we can get through for sure all 3 steps before the next court date is the plan. And I think that covers everything. I'll let my esteemed colleagues correct me if I've misstated anything.
All right, well, we'll start with Ms. Gustafson and then go to Mr. Baldwin. Thank you.
I believe that covers the possession and access agreement, Your Honor, and the other provisions that we discussed to get us to a final hearing. There is a counter petition on file regarding conservatorship. So we do need probably at least 3 to 4 hours for a special setting.
All right, then, Mr. Baldwin.
I think the only thing I'd add to the recitation of the agreement is it's understood that when the overnights start.
The judge carefully weighs both sides before making a decision. While the mother raises valid concerns, the court explains that social media photos alone don't prove someone's actual income. Without stronger evidence, the judge can't assume the father is hiding earnings. Instead, the court adjusts the payment in a different way, reducing the medical support while increasing the monthly child support amount.
March that Mr. Maddox is going to be with the child at his sister Nicholin Weber's house. And I guess after the March visit, if that changes, he will let mom know, where he's going to exercise his 4-day period of possession, just so she knows where the child is, basically, because I think he's going to be exercising his periods of possession in Texas, at least until we get back to court. So that's all.
I'll let y'all iron that out if it's necessary. Folks, Judge is probably looking at taking time off and to get his, get that knee replacement thing going. So I'm probably looking at the first couple of weeks in June instead of the late May. Would that work with you guys? For y'all to come in?
Yeah, that'd be fine. I think that'd be fine.
In this case, probably based on this circumstance that's so negotiated, if I'm still not back, then Judge Law will probably take care of it also. But I'd like to keep it on mind. And right now, I know y'all saying I know Friday's supposed to be okay. Well, I couldn't remember, was it Monday or Wednesday y'all were looking at?
Monday afternoon, or anytime on Friday seems to be the best for all the attorneys. So,
Okay.
and I don't, June is wide open for me. So any Monday or Friday in June works for me.
All right, the only Monday I don't have is the second Monday of the month for Comanche County. So I could do it any Monday. And you say you want the afternoon and not the morning, correct?
I mean, I'm fine with the morning. I assumed there was. I assumed the court had,
Okay, I got both slots available, 3-hour slots. I usually do 3 hours. I got the 9:30 slot available, and I got the 1:30 slot available on all Mondays and Fridays, except for the second Monday of the month when it's the Comanche docket.
Okay, yeah, I'm good with any Monday or Friday.
Any of those,
You have a preference?
any of those is fine with me.
Okay, how about you, Mr. Bowden?
I'm sorry, we're talking about the first 2 weeks in June?
Any Monday in June except the second Monday, and any Friday in June except any Friday in June period is okay. So everybody else says any of those Mondays, the first one, the second one, the third, and the fourth one is fine. Any Friday is fine with them. The first one, the second, third, or fourth one. If you have a preference on any of those, sir, let me know.
Monday the 8th and Monday the 22nd would be my preference if we're picking.
22nd, Monday the 8th is my Comanche docket. So the
22nd fine. So June
22nd
20,
works.
June 22nd at 9:30.
Works for me.
Okay.
All
That's
right, folks,
too
I'm gonna go
easy.
ahead and make the Zoom code and I'll get that out to the state and y'all have that, that new Zoom code in the next few minutes. I'll go ahead and, obviously, I'm gonna go ahead and let y'all confirm this information with your clients that they're in agreement with this under oath. So let me go ahead and get them under oath and y'all confirm that this is what y'all gonna do going forward. So at this time, I'll ask both the parties to raise your right hands, please. Do both of you solemnly swear or affirm your testimony you're gonna give here today is the truth, the whole truth, and nothing but the truth, so help you?
Yes.
Yes.
All right, but thank y'all both very much. I'm gonna let the Mr. Brimhall call y'all as witnesses and then let y'all's own lawyers follow up. And again, y'all heard what the agreement is. It's a long one. Believe me, the judge just wrote down, agree to break-in visits, okay? So, yeah.
Okay.
Otherwise, I'll still be writing. So the bottom line is I'll let y'all confirm that this is okay with y'all, with both of you, and we'll get that order prepared and I'll go ahead and start working on the Zoom code. Thank you.
Thank you, Judge. I'll call Miss Johnson first. Can you hear me okay?
Yes.
All right. Were you able to hear everything I announced at the beginning?
Yes, sir.
Is that what you agreed to?
Yes, it is.
Do you have any questions about that? Any of it?
No, sir.
Okay. Any part that's unclear?
No, it was very well spoken of.
Okay. All right. I'll pass.
I don't have any questions, Judge.
I don't have any questions.
Okay. I'll call Mr. Maddox. Mr. Maddox, can you hear me?
Yes, I can hear you.
Were you able to hear me read or announce the agreement that's proposed today?
Yes.
All right. Is everything that I announced, does it constitute your agreement as well?
Yes.
Okay. Do you have any questions about anything that I announced?
No, sir, I do not.
Is there anything that you are unclear about as it pertains to the proposed agreement?
No.
Okay, I'll pass.
I don't have any questions, Your Honor.
No questions.
All right, Mr. King. All right. All right, folks, I'm gonna go ahead and let your lawyers prepare that order, circulate it, review it, and sign off on it. I've almost finished doing the Zoom code, but I'll have that out in just a few minutes. Is there anything else at this time, Mr. Brimhall?
No, nothing further, Your Honor.
Ms. Gustafson? Anything else, ma'am?
I'm sorry. I don't believe so. It kind of broke up for me. I had an alarm go off to tell me to join your 1:30 docket, so I apologize.
Oh, well, I hope you're not late, okay?
Yeah, I hope not.
All right, then. Mr. Baldwin, anything else, sir?
That's all for today, Judge. We already have a draft of the agreement and order circulating, so hopefully we can all get that signed today or tomorrow and we'll be in good shape.
All right, Ms. McKinney, anything else, sir?
The only thing I could think of was we're gonna reserve retro for the final two, but that's it.
All right. All right, I'll see. Hopefully I'm the guy doing this and I won't be limping as bad when I see you guys next time. So anyway, I'll see. Anyway, thank y'all all very much, and we're off the record. And let me get back as soon as I'll go ahead and get this Zoom code out, and then we'll look at get ready to do the 1:30 docket. We're off the record.
Your Honor, the state has completed an order that conforms with the court's ruling at the last hearing. Essentially, we transferred what were temporary orders into the final order with some provisions regarding visitation and access, and then the addition of a retro finding against Mr. Kyles. I'm not sure if Ms. Lopez and Ms. Farrell have had an opportunity to review their email, but I would let both those folks know there's a order that's been circulating for your signature and approval. I don't know, based on the last hearing, of any problems or concerns about the proposed order. And certainly my hope is that Ms. Lopez and Ms. Farrell will be in agreement and be able to sign it.
All right, Ms. Gustafson.
I had no problem with the order. I do know that Ms. Lopez had concern about money that had been withheld that she had not received, but it's my understanding they needed an order in order to send the money to Ms. Lopez. And so I think if the order is signed, that will solve her problem.
Okay, Ms. Lopez, the norm is that, yeah, that they need a court order before any monies can be released. And I'll allow you and Ms. Farrell to make any, ask any questions at this time or tell the court why you're in agreement or not in agreement with the court signing this order and getting those funds over to you or being sent out one way or the other, or whether or not you had a specific problem with the order and had a chance to review it. Technically, you're both your own representatives. And so, Ms. Lopez, have you received a copy of the order or had a chance to review it and tell the court what you want me to do?
I'll agree to whatever's on the order because I have no problem. Beverly Sproul has been helping me a lot with the girls. So whatever Beverly agrees to, I agree to.
All right, then. So again, obviously the state's prepared that, send it over. So Ms. Farrell, do you have any objections, anything at this time to the court entering that order?
As long as I'm not paying him any money, I don't care. He don't need none of my money.
There you go. I know there's a lot of people
If my money, we have a whole problem.
Well, man, there's a lot of people that don't need my money, but they sure as heck taking it. But the bottom line is,
Tell me about it. Tell me about it, because I pay my child support. Okay, so I'm tired of them trying to give my money to him.
okay, well, they're going to give it to
He
them.
don't even
Obviously,
take
it
care
goes
of
to
a
Ms.
kid.
Lopez, ma'am. So again, that new order will take care of that. So do you have any objection to me signing off on it?
No, sir.
All right, then, everybody, I'll sign off on it. So the ad litem has already done it. Mr. Coates, I'll have you circulate that. Send a copy to the parties again. Just make sure they got it. But go ahead and send it over to me for signature, and I'll sign it without their signatures because everybody's in agreement on the record.
Thank you so much, Judge. And before we part ways, Ms. Lopez and Ms. Farrell, please check your emails. There should be, it'll come to you first, Ms. Lopez, and then to Ms. Farrell for signature on the order, okay?
Okay, all right.
Okay. Thank you,
Yes, sir.
ladies.
Thank y'all all very much. Everybody be safe out there, and hopefully it won't be 100 degrees today and 32 tomorrow, but we'll see.
All right. Thank you,
That's
Your
what you
Honor.
get when you live in Texas. You never know what you're gonna get.
Well, my college roommate's an MD in New York City, and he's had 3 snowstorms this year, so I'll live with Texas for now, okay?
That part. Look, thank you. I'm with you.
Thank you.
Thank you. Bye-bye.
Your Honor, may I be excused?
Oh, yeah. And of course, my college roommate decided to get married a 3rd time, and now he's got 2 10-year-old boys running around. And and he said they're snowed in, and he's not happy. So, yeah.
I know that's right. I would be like, go get a job.
But 10-year-olds don't like working, and they say they figure if dad's an MD, dad can bring home the bacon and take care of everything. Okay.
Oh,
That's mama.
I was like, that sounds like me. That's
That's
me.
mama doing that. She's bringing home the bacon. Take care of
There
her
you
little
go.
babies.
Thank you, ladies. Y'all free to go. Thank you.
Okay,
You
thank
too.
you so
Thank
much.
you. Have a great day.
You too now. Thank you.
Bye-bye.
Yeah, I just can't do the snow. Okay. There we go.
Me neither. I can't do this stuff. Oh, I'm so old school. Lord, help me, Lord. Take this up. Every says turn.
Yeah, that's that. You see, now you sound like my mom, Ms. Lopez. No problem, ma'am. She was one of the best. Thank you. Bell County calls number 269-263, and this is the interest of Butler minor children. Knockastillo party is Otasia Taplin, and this is in the interest of at one time 1, 2, 3, 4, 5, 6, 7, 8. Okay, eight minor children, all named Butler, Mr. Butler's children. Anyway, the court will take judicial notice of the court file. Note for the record that we've been operating under a temporary order in this matter since August of 2025. That the temporary order involved a hearing where both parties appeared and agreed and signed off on that original order. However, there's been 2 or 3 resets on this matter, and neither party has appeared for those resets. And this one right here, I'm noticing that there was a proper notice of reset on this matter as far as this case is concerned for today's date, February 26th at 9 a.m. My understanding, neither Mr. Butler or Ms. Taplin appeared. So I'll ask the state for an open to tell the court what the state's requesting we do here today as far as what to do with that temporary order from 2025. Thank you.
Yes, Your Honor. Thank you. The state's asking that we get the temp order signed on 8/18/2025, just finalized as is.
All right, court will so grant. Both parties were here, both parties signed off on it. And if I had to deal with 8 kids, I might not show up either, Mr. McKinney, okay?
Yes, Your Honor.
Oh, yeah, that's a lot. Anyway, I'm assuming hopefully some of them are grown and gone. But anyway, I'll go ahead and ask you to prepare a default order, noticing that neither party appeared, but both parties have previously appeared. Both parties have previously before given testimony, and based on that testimony, the court's going to finalize the order that we did last year as far as the circumstances is concerned. And I will ask you to forward them a copy to give them an opportunity to sign off on it. But if they don't get it back in the appropriate amount of time, forward it over to the court for signature. Is there anything else?
By the end of the hearing, neither side got exactly what they wanted, but the judge tried to reach a balanced solution based on the evidence available. The case is a reminder that in family court, claims alone aren't enough. Every allegation must be backed by reliable proof before a judge can change a support order. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.